Welcome to Innovator Café, the entrepreneur go-to, with your host, attorney Dave Stevens. Through each episode, Dave and his guests provide resources and assurances to build a company growth roadmap. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and the website stevenslawgroup.com. Now here's the host of Innovator Café, Dave Stevens.
Yeah, hi, everybody, and welcome again to Innovator Cafe. Today, I'm flying solo, and I want to talk about something that, of course, is near and dear to my heart and what I do, and that's managing intellectual property. So it's intellectual property management for entrepreneurs. And this can be shared with your general counsel, your IP counsel, your attorneys, anybody who works with your intellectual property. But I'm really gearing it also toward the company folks who are, they leverage and use the intellectual property. I want to impress upon everybody here that intellectual property, understanding intellectual property, protecting it, and utilizing it in your business is not just for the legal team. It's not this dark, esoteric kind of black box that a lot of people see that it is. And anybody in the company can become an intellectual property expert, right? And certainly can learn how to utilize and leverage intellectual property for your business. Today, we're going to talk about building and protecting the intellectual property assets. And part of it is, your approach to protecting your assets has everything to do with how you're going to use your assets. You can overprotect, you can overspend for sure in protecting your intellectual property assets. But when you align it with your company goals and your business strategy, how you're making money, your revenue, how you're procuring products, how you're selling products and services. Once you align it with that, then you're really making a true investment in your intellectual property that will pay back in your business goals. So a good way to look at IP asset management is to understand that ideas, innovations, new things, these are things that are passed around your company. Everything becomes intellectual property asset, but after it is created, and everything starts out as a trade secret. So every intellectual property, every item of intellectual property that you own starts out as a trade secret. And after that, you utilize this, and it's you either have to protect it as a secret or protect it as an IP asset with patents, trademarks, or copyrights, or keep it as a trade secret. But you want to categorize it. And once you've categorized it, you want to protect the important stuff that matters to your company, right? The goal here is to be a sophisticated consumer of IP services, because that's what this all centers around. And as long as you understand your intellectual property, how you're using it, you're going to understand how to use your IP services and also how to utilize your intellectual property. It really is a partnership with your outside counsel and the inside players who are, the stakeholders are actually using your intellectual property to really get most of the value out of your intellectual property. And the image that I'm showing here, it shows closed innovation versus open innovation. Now, this is the concept, closed innovation, open innovation, that is used in modern days really to really shine a light on how intellectual property is used in companies. In older companies or defense contractors, where heavy secretive companies, closed innovation has always been the norm. Nothing coming from the outside in, nothing going from the inside out. All of the ideas, secrets, innovations are kept internal because secrecy is of the utmost importance. But in most companies, modern companies that produce consumer products, that deliver services and products to businesses, it's more of open innovation. And if you look at the graphic, you can see there's external collaborators, there are alternative markets, there are partners on the outside, there are customers themselves who put their intellectual property in your care sometimes, or they just give you their requirements, the things they're looking for, and you create things, and these things have intellectual property once you've developed them. So you want to have an internal person, not just an external counsel, but a strategic expert in IP development. And you don't need to be the registered patent attorney or any kind of attorney in order to be that expert, but you want to be well informed on the inside so that you know the services that you're paying for. You understand what you're getting for your money, but most importantly, you understand your intellectual property, how to protect it, and how to utilize it, right? So managing the audits and structure of your intellectual property portfolio is very important. Auditing, we'll get into we'll delve into what auditing really means, but it's really about understanding your technology, your ideas, your business concepts, your business roadmap. All of these things are combinations of intellectual property, copyrights, patents, and trademarks, but also secrets, business secrets, not just technical secrets. Trade secrets reach into all types of information, strategy, data that your company uses to better itself over its competitors. Keep in mind these graphics when you're thinking about intellectual property and how it's being used by stakeholders in the company. Often you're sharing it with the outside. You're even sharing it possibly with customers, partners, vendors, and you want to make sure that you understand where your intellectual property is, where others' intellectual property that you don't own is, stuff that you need licensing to, and other information you need around your intellectual property so that you can understand how to protect it, continue to protect it, how to educate your employees how to utilize and protect it, and to maintain a long-term plan for utilizing your intellectual property. So there's really three pillars of sustainable innovation culture. That's really what it's all about, sustaining your innovation culture. You want to build a culture of innovation, and it's something that needs constant nourishing. And it's constant nourishing by encouragement of employees for reporting and sharing their ideas with the company so that the company is aware of the new ideas and concepts, intellectual property that's being created. Regularly auditing, structuring, and budgeting your IP portfolio so that you can keep control over how things are being managed. Budgets can really go awry if you don't pay attention to what you're actually protecting. For patents, for example, I mean, they're expensive to start with. When you start filing in foreign countries, which often happens with companies that are exporting goods and importing goods, it can get really out of hand. The foreign filing costs can be 5 or 6 times the cost of your domestic intellectual property protection. And if you don't keep a close eye on it, it could really get out of control. Out of control meaning you might end up with assets and extraterrestrial protection that you don't even actually need, but you're going to be paying heavily for. And finally, and very importantly, utilizing your company IP for revenue generation and negotiations. So you want to create first a culture of innovation. You want to take this holistic approach where you're looking at the company and why do you have IP? What role does it play in your business? How do you make money? And how does intellectual property help you leverage your ideas and concepts that your creative people are creating? That includes all types of creative people, whether it's in writing and content, inventions and things, designs. It's important to understand what's really valuable and important to your company. You want to be aware of your intellectual property and you want to get visibility of it. Ideas can be kept secret, they can be passed around the company, and unless you really understand and encourage proper communication, control, and protection, you could lose your intellectual property. You could just not even be aware of valuable intellectual property that's just sitting around and no one is using it, incorporating it into products. Some may even be hiding it for their next job or somehow protecting it for themselves. It happens. And you want to be able to, have this open conversation, this open culture of innovation in your company so that you will be able to at least have visibility on all the intellectual property, and at the management level, decide if you want to protect it and how you might utilize it in your products. So protecting valuable ideas. So there's many ways to protect valuable ideas. As we said earlier, everything starts as a trade secret. It's an idea. It's in someone's head somewhere where they've thought of something that's going to somehow better your business or the products that you're producing. From that stage on, they need to share it somehow, whether it's reducing it down to writing, sharing it with coworkers, and maybe even going further and filing for patent protection, copyright protection, filing trademarks, right? Trade secrets and IP, all of these things exist, whether it's in the technical side with engineers and developers, design side, or even with the business side, marketing and sales. Much of the leverage of intellectual property can come from the sales, negotiations, and marketing approaches for your products and your services. And intellectual property can be leveraged by these people who are not even creating it, but they need to understand it so they can leverage it properly. Most importantly, no one's going to do this for you. Time is always the enemy when it comes to intellectual property protection. And we'll get into the different types of intellectual property, what types of timing constraints there are to protecting them, how you protect them. But you need to lead the charge and get everybody's buy-in. You need to make sure that management, together with everyone who's creating intellectual property, are having this robust conversation so that the decision makers are aware of the intellectual property and they have visibility and control over how it's being protected. First question you want to ask is, why are you protecting your IP? And for many of my clients that I talk to, especially when I first meet them, they think they know this answer. And it really is not self-evident, right? Why are you protecting your intellectual property? Why are you filing patents? Why are you filing for copyright? Why are you setting up a system for protecting your trade secrets? Well, you want to understand how intellectual property is being used in your regular cycles of business so that you know where the potential losses could be and also where the potential advantages and opportunities there are by leveraging your intellectual property. Patents, trademarks, copyrights, they can be used as a deterrent against lawsuits. You want to show that your company has this strong attitude toward protecting its intellectual property, and it also has this culture of sharing and using intellectual property internally. There's no better target for IP infringement than a company that is careless, a company that is not paying attention to its IP, who is loose, not filing any patents, or not filing the proper patents that are valuable to your technology. It gives you credibility in the industry when you not only are a strong producer of ideas and good products, but also you want to show that you are protecting your intellectual property so others will take pause before they steal or borrow or somehow copy your intellectual property. And in many cases, if you don't protect your intellectual property, you're dedicating it to the public. You're sharing it with the public, and they're going to use it with impunity. So you want to be able to really understand what's valuable, what's protectable in your intellectual property, so you can make these proper decisions so you look like this serious company, so people won't just knock you off. It also gives you credibility to your customers, because what is really unique to you? Is it your brand? And it can be business credibility, product quality, the warranties, all these things that you stand by in your products. Are you really serious about this? And the more serious and dedicated you show yourself to be with protecting your intellectual property, then the more integrity your company has in every aspect of its business, whether it's talking to partners, dealing with competitors, and sharing with customers, right? Selling to customers, standing by the warranties and the guarantees that you make, showing the world that you are an innovator and that you are constantly working to improve your product by developing new ideas, innovation, research, and development. It shows that you have a robust, innovative culture. You have robust research and development, and intellectual property is really the documentation and the certification of all of that. And think about this: when you're filing patents, when you're protecting things with copyright, you're telling the world, as well as the people who are creating these things for you, your employees, that you're doing something that's never been done before. There is really nothing else in this world that certifies that you as a company and your inventors and creators, your developers in your company, it's that they've built and created something that's never been done before that's really useful. It certifies that. Nothing else does it like that, right? It also gives you the ability for exclusive use of technology. Patents exclude, it gives you the ability to exclude others from utilizing your technology, right? You can leverage this in business negotiations, because when you have exclusive use of your technology and your brand, your code, and your content, it gives you really extreme leverage in contracts, and it gives you the ability to negotiate better positions when you're doing things like joint developments, or even in positions with your customers to only purchase things from you exclusively. And in a new movement, a very quickly developing area of intellectual property is using it as collateral for loans. Now there are many funding sources, banks and other funding organizations that will loan money leveraged and collateralized exclusively on your intellectual property, which is extremely valuable. So although it puts it puts leverage, when you put the leverage of the IP at risk in a loan, it does put it at risk, but at the same time, it gives you the ability to borrow money in areas where you might not have any leverage to borrow money. So if you're able to leverage the intellectual property, you could borrow money even if you're not selling products yet, because these sources that look at your intellectual property as a source of value, they collateralize it. You could take that value and turn it into an interest-bearing loan that you couldn't do before you had products and assets that a bank could actually collateralize. So lots of ways to protect IP. Ask yourself why you're protecting IP, and talk to the experienced individuals who understand, this is why we're protecting our IP. Tell us how to protect our IP. And it starts with an audit. It starts with an audit. It doesn't matter if the company is on, it's small, it's an idea on a napkin, it's a startup company, or it's a large organization. Typically, the larger organizations they don't step back or take pause to audit their intellectual property. And when they do finally audit their intellectual property, what they learn is that there's a lot of IP that they're not utilizing, or they're maybe overprotecting it and overspending on the protection. And when that happens, you have lots of options. You can sell off your IP, which doesn't mean that you can't use it. What it means is that other people who need IP can utilize your IP, and you get a license back. So you have the ability to use your intellectual property, and you could sell off this intellectual property, have some revenue from that, and also relieve yourself from the maintenance costs of maintaining those different types of intellectual property assets. Patents, trademarks, copyrights, and trade secrets. These are the tools of protection of your intellectual property. Again, everything starts with a secret, and if you move these forward into other ways of manifestations of intellectual property, you can develop new assets, patents, trademarks, and copyrights that give you the registered asset and the ability to leverage these things and also to protect your company. If things remain a trade secret, you're limited to the protection from secrets that, of course, that you are able to keep secret, that are not revealed when you sell your product, that are not revealed by your marketing or your sales, or any outward expression that you have of your products, whether it be at conferences, on your websites, or at sales interfaces. You can keep things secret, but the things that you cannot keep secret, things that are exposed when you sell your product and when you discuss your product, you need to take, if you want to protect it, you need to take deliberate action to protect your patents, trademarks, and copyrights. And time is the enemy. You need to audit these things. You need to know when these things are created. What are these things? What are the details? Where does it sit? Where are these things documented? Are they documented? Right? Are they only in the heads of the inventors or the creators? In order to manage anything, you need to be able to document these things with intellectual property. And it's very important when you do this to utilize an experienced auditor. And the auditor is not, it's very much like accounting auditing, but the auditor in this case is someone with a deep intellectual property background who knows the industry, who understands the IP landscape of your company, competitors, and other stakeholders, even your customers. You know, what intellectual property do they hold? And as a customer, you can also develop intellectual property that gives you leverage against the companies that you're buying products from. And here's an example. Let's say, well, one example is an energy company that needed the software to read 40 million energy meters every 15 minutes. That's a big problem statement, right? They didn't have the ability to make it themselves. They wanted to hire an outside company to do it for them. Now, there's two ways that you can approach this. One is just hand over the problem statement and pay a company to develop that for you, or protect some of the intellectual property because you've got some ideas there. You've already come up with a problem statement. The problem statement is the beginning of the solution statement, which that's where inventions come from. That's where patents can be protected, trade secrets, copyrights. It's when you start to solve the problems, technical problems, or even business problems, where you can come up with these solutions. The solutions are intellectual property, and often they are patentable inventions. So you want to spend some time, even as a customer, if you're putting out something, you're asking for a new product, especially a product that doesn't exist yet, you're having somebody develop it, you have the ability to control that product. So let's say that you have the product built and you pay the money for it, and you might have a subscription, like it says, a software system, and you are having a company develop this for you, and you'll probably pay some kind of subscription or maintenance for it because they're going to want it. You're going to want them to maintain it while you're using it. So you're utilizing their expertise. You're continuing to utilize their expertise in the development, improvements of the software, whatever the product is, and maintenance when things fail, when they fall short, and just when they can generally be improved. If you own intellectual property on the thing that's being built for you, you have a bit of control over that. For example, let's say this vendor isn't working out, or you find another vendor that you think can do a better job. They might even be able to develop a new product. They might even have a new product. If you have patents on this particular product, then you have freedom to operate. You have freedom to choose another vendor to develop your product for you if needed, or to have multiple vendors develop products for you. And as a large company, or even as a small company, it's good to have these alternatives. What if somebody comes short in one of your vendor providers, and you want someone else to pick up the slack, or somehow their product fails, or they can't fully support you? You want to have the ability to reach out to another company who can also supply the same services, maybe utilize both of them simultaneously. And the best way to be able to control that is to own the intellectual property that they are developing, maintaining, that they are improving and upgrading over time. They're constantly researching. You can have control over that because you can have underlying intellectual property that gives you the leverage to control that. And of course, with leverage, all you negotiators out there know that you can negotiate prices down, and you could have, even a partial exclusive use of the intellectual property, allowing them to sell them to their other customers, but possibly giving you an exclusive use for a period of time, 1 or 2 years, and maybe keeping them from selling it to one of your competitors or selling it to someone who might threaten your business somehow. So leverage, intellectual property is used for leverage. Competitors, customers, partners, collaborators, and even anybody who's in your ecosystem, in order to have some kind of control and leverage over them, intellectual property can give you assets that can give you incredible ability to control and to leverage these different things in these business negotiations and in your ongoing business operations. So let's talk about the different types of intellectual property. There's copyrights, patents, trademarks, and trade secrets. And I'm going to go over this lightly because this is a bit of a primer on these things. But in order to know how to protect these things, you need to understand a bit of what they are. So copyrights, typically we hear about this in terms of in the tech area with software and things, right? So copyrights are registered. Copyrights not only protect content, they protect books, videos, movies, things you typically see copyrights on, right? It also protects software and any type of marketing content, sales content, because often when you're knocked off, when people copy you, they're copying everything about you. In fact, we've even seen on e-commerce websites such as eBay and Amazon and things where knockoff products show up, and they actually even use your photos of your product to advertise their products on these different platforms. So you want to make sure that you have copyright protection on all of these things. Now, you're not necessarily going to copyright everything, just like you're not going to patent everything. You're not going to trademark everything. But you want to be strategic and choose the things that are choke points to your product, to your industry, choke points to your supply chain. So if someone else is knocking you off, you can use these strategic intellectual property assets in order to stop them, or maybe even get revenue from them. Patents are a bit more complicated, and patents, people have characterized them as a game of kings, and it's really not the case. They can be expensive, but when you're strategic and you are judicious in what you are choosing to protect, they can be extremely valuable. And with properly protected, a modest investment in patents can give you an extreme amount of value and leverage. So the first question you want to ask, why are you filing patents? And you may not know the reason. You might think, oh, we have this valuable technology and we do protect it, right? And you understand on the surface that there is something valuable there and that it can be protected. But in order to properly protect it and not to overspend, not to overprotect it, you need to understand, it's helpful to understand why you would use these patents. How would you use these patents? Why are you protecting these things, right? One thing is for sure, you need to protect these things before you utilize the IP. And you want to understand the landscape around the intellectual property of your products and of your competitors, so you can understand where you fit in. And if you do, for example, a landscape search, you look at your competitors' products, you look at their intellectual property, look where everybody in your industry are filing patents, copyrights, and trademarks. It will give you a view into how others are behaving. And if you're a small company, and if your ambition is to get acquired by a large company, it's really good to understand how your potential acquirers, the large companies that will acquire you, how they treat intellectual property. If you can see that and get a view of how, if they used your product, if they created your product, how would they protect it? If you do it in the same manner with a similar strategy, it makes you even more attractive for them to acquire. And they will pay more money to you because you will fit in better with their company, with their assets, with their products, with their services. And if you protect them and behave as if they are like you are like them, then it will be a much easier and friction-free type of acquisition because you'll have the intellectual property assets, business processes, so that it shows that you'll fit in better and it'll make you much more valuable. And like all things intellectual property, most importantly in patents, you want to have experienced IP professionals. And not just to toot our horns, it's something we've been doing for many decades. And it's important for whoever you're working with. This is not an area necessarily of young ideas, right? Of young professionals. It's really important to have people working with all types of people, diversity of people, but you want to have people that have deep experience in protecting and utilizing IP assets so that you can understand how to protect yours, right? And you want to set expectations before you even get started. So you bring in your professionals, you do your audit, you understand the IP landscape, you start to answer the question of why are you filing patents? That can even change over time. You might just want to, we want to capture this. Time is of the essence. We need to file patents. We do all these things. But when you start developing and building a patent portfolio, it becomes more expensive, becomes more valuable, but you want to make sure that you really keep a lid on cost, of course, and you want to make sure that you're not leaving things out or ignoring things that can be valuable to you, right? And you want to prime this innovation process so that you're getting all of these ideas, you're understanding all the inventions your engineers are coming up with, all of the concepts that your marketing people, your salespeople are coming up with, and you document these things somehow. You share them internally so that everybody has visibility on them that needs to see them. And you can protect the things that need to be protected, keep secret the things that can be kept secret, and you're going to give away things that are, valuable to your marketing and your sales and the goodwill of the company. For example, automotive companies, Volvo and Mercedes-Benz, they developed all types of safety mechanisms, airbags, seatbelts way back when. And they decided they're just going to share these things for everybody to use so that everybody feels safe. And it added an extreme amount of goodwill to the company, just giving away this intellectual property. So you see, there's many ways to do it. And you want to, when you're looking at what is your IP, cast a wide net and look. But after you ask the question, why are you filing patents? What are you utilizing? What's valuable? Talk to your marketing and sales people. What are your customers seeing as the valuable thing? Why are they choosing your product? And that's the first place to look, and keep your eyes open. So when you're looking at the technology, you're looking at the innovations, you're looking at possible inventions, potential things that you might want to patent or copyright. You want to keep your eye out for these things and be, hyper aware when you find these things so that you spend extra care and protect these things. And these are the things you might also file and protect in foreign countries. Again, it gets more expensive. You're not going to protect everything internationally. It gets really expensive, certainly not in every country. 185 plus countries provide intellectual property systems for protecting your IP. If you filed in every country, you'd be spending millions on any one single invention, tens of millions. And you don't need to do that. So you want to have that strategy, right? And you want to be able to focus on the things that are very important, right? You want to look at organic inventions where you're developing a product, you're solving problems, and your engineers are putting together your final product, whether it's your MVP or you are improving your product, constantly developing your product. The organic inventions are the things that they're piecing together to make your final product, right? There are other sources of intellectual property. So in order to understand what those are, you want to open your mind and understand how you would utilize intellectual property. Competitor roadmaps, Customers, potential customers, what are they looking for? What are they looking for now, a year from now, 10 years from now? You could look down your roadmap of products that you are proposing to make and develop. You can start inventing things that are not going to come out for years. And the earlier you protect them, the more powerful and the more thorough your protection is, because you're beating everybody to the punch, right? Customers, competitors, all these different ways that you would use your intellectual property to strategize. How are you going to make your product? What features are you adding? In software, it's the functions and features. If it's a product, if it's an automobile, if it's a bicycle, if it's a laptop or a phone or a smartwatch. The smartwatch I'm wearing here, it seems, well, it's not quite simple. Actually, it's very complicated. It's very useful, but there are thousands of patentable inventions in this thing that you just don't see. Software, hardware, firmware, touch screen, even the hardware that holds the device together, that holds it on your wrist. Many sources of intellectual property from the organic inventions that you're developing. But if you look at your competitors, you can see where they're developing. And when you're protecting your inventions, their product might be different. You can imagine that their product line might be different in ways where your invention might be utilized differently by them in their product. They have a different platform. They have different types of hardware. When you make an invention, you develop an invention. If you file for patents, I always tell my clients, you can dream your dreams in the patent. Any way your invention can be utilized, you can protect that, you document it, and you claim it in patents. So you could actually cover your competitor's product if they add the features that you came up with first. Now, think about what is valuable about patents, right? You say you're protecting. They always say this: we're protecting our products, we're protecting our intellectual property, we're filing for patents. What does that even mean? Patents don't enforce themselves. When you have patents, and if you want to utilize these patents, whether you're going after a competitor, you're trying to shut them down, stopping them from using your features, or if you want to license it to your competitors, or even unrelated areas where you can get revenue, you want to understand the patents and how they apply to these other products that you don't even produce. And I'll give you an example. Hewlett Packard, they're very well known for their inkjet printers. They were the first ones out. They made the best ones. And they made an enormous amount of money, not just off selling the printers, but selling those inkjet cartridges, right? The gift that keeps giving. You have to constantly buy these things, right? The engineers who developed the inkjet printers, the inkjet cartridges, these are very precise inkjet sprays that can produce different colors and print things on paper, extremely precise. Well, it occurred to them that there are other utilizations of the nozzle spraying that sprays the print. And what they came up with was they could come up with new ways in automobile internal combustion engines, gas burning engines, to make them more efficient, where they're spraying gas fuel through these nozzles in a more efficient way, in a way that can save gasoline, that can utilize less fuel for the same power, all these different things. So the Hewlett Packard engineers filed a bunch of patents that apply their nozzles and different technology from their inkjets in automotive applications. And they made an enormous amount of revenue licensing this to the automotive companies. And they weren't just suing them for patent infringement. It's not what it was. They were offering a new solution, a new technology. They were selling them a new technology that made their engines more efficient, and they happily paid it. And how did Hewlett Packard support that? How did they make that revenue sustainable? They filed patents so that if anybody decides not to pay them a royalty or pay them some kind of licensing fee, and they just utilize it anyway, they're going to have to pay a price. That's what backs up these royalties. It backs up these licensing payments. You have patents that are a threat, right? So it's a carrot and a stick, right? So The carrot is, hey, we're going to give you this technology. We're going to give you our know-how. We're going to show you how to utilize this in an engine, for example. And if you don't pay your revenue, if you don't pay your licensing or royalty fees, we've got the stick, we've got these patents, we're coming after you, right? And that type of threat is usually self-evident. You offer this as a gift, as a valuable product that they can utilize. And if they decide to take it rather than pay for it, then you've got the patents to back it up. They're more likely to pay for it if you have the proper intellectual property. So patents, very important to get experienced people, experienced professionals that understand how to look at a landscape, how to look at patents, how to utilize and to value them in order to help you protect them. The most valuable patents, the purpose of patents, is to place risk in the roadmap of other companies that will utilize your intellectual property without paying for it. You could plant risk in the roadmap of your competitors. You can plant risk even in the roadmap of your customers so that they'll understand that what they're getting from you is unique, that is proprietary, and that they won't necessarily resell it, or maybe they won't even buy it from another source, knowing that you are the source, that you have the superior research and development, and that you own the intellectual property on your inventions and the products that they're buying. Trade secrets. Actually, probably could have just started with trade secrets, because I kept saying that everything starts as a trade secret. Well, however you decide to protect your intellectual property, everything does start as a trade secret. But in order to protect trade secrets, you need to catch them at their origin. Usually starts from collaborators inside your company, your employees, and they come up with ideas, whether they're technical ideas, marketing ideas, sales ideas, business strategy ideas. How are you making money? Are you giving some things away? Are you charging for some things, right? These are trade secrets. These are secrets that give this company a competitive advantage because nobody else knows these secrets. And they might come out at a later date, but it can give you, the first step in a direction that will give you the best first mover position that can build your product and your company and make it much more valuable and make it much more difficult for competitors to catch up, right? So what is a trade secret? It's information that's not generally known to the public. It can actually be available somewhere in the public, hidden from use, and maybe not. It might be in areas where your competitors, product developers, might not readily look. So it doesn't even need to be this thing locked in a box in your company, like the Coca-Cola recipe, right? Or the software source code. It can be just the secret that gives you an advantage as long as you are able to take advantage of this without others knowing about it. It has to have commercial value because it's secret, right? So if you looked at your company, if you were going to look and see how many trade secrets does your company have, you could probably fill even like this office of mine full of ping pong balls where each of them represents a secret, and you would fill them to the ceiling. You can't possibly see or protect or even know about all the secrets, but you want to go after the things that are valuable, and they're valuable because they are secrets. And you want to make sure that you take steps to protect them. And how do you do that? Well, for any company, it needs to be this reasonable effort to keep things secret. You keep your doors locked. You don't give outsiders, non-employees, or anybody who's not under contract of confidentiality with your company, vendors, sales, even customers, signing NDAs. That's what these things are for, right? You want to make sure that anybody who sees these secrets are sworn to secrecy to your company, sworn by contract, right? So you want to make these reasonable efforts to protect these trade secrets. And you also want to try to document as much as you can your key trade secrets. Again, you can't document them all. You can really go overboard. And the larger a company gets, the more trade secrets you have, and the more difficult it is to find every single one of them. It might seem easy as a startup company with a couple of founders, just a couple of people with their eyes on the product and development to understand what the trade secrets are. But you're not, as you grow, you're just not going to be able to track all of them. You're busy doing business. You're busy developing products. You're doing other things to make money, and you can't just focus only on secrets. But you want to be able to try to document and maintain what you have. And what does that mean? In order to protect your trade secrets, first of all, you have NDAs whenever anyone is looking under the hood, looking at your technology, looking at things that are not generally known to the public that are inside your company. If it's on your marketing copy, if it's on your website, those aren't secrets anymore. You can't protect those. They're not secrets, right? If you patented them, if you copyrighted them, you have protection, right? Trademarks. But with trade secrets, they need to be kept secret, right? And to document them, you do the same thing that you do when you're documenting your inventions that you might file for patents. In fact, you treat them all the same way. You can document valuable trade secrets, keep them internal. And you want to make sure that you can verify that it's been documented and verify with a timestamp with the details. And there's lots of software products to do this. There are lots of systems, wikis, internal, Wikipedia type things that are only seen inside the company, where you can document and date these things and be able to verify the date in which it was documented. Now, why do you need that? A trade secret is something that's created in your company, and it's relevant when it is created. If someone leaves your company, an employee, joins a competitor or starts its own company to compete with you, uses your trade secrets, if you're going to go after that company or person, then you need to verify that your company had possession of that trade secret before it left, before it was stolen, before someone took it, right? And so it's most helpful if you can verify, document, and the date in which it was created, so it shows that you have possession of this trade secret before it was misappropriated, it was stolen. Even if it was inadvertently taken or utilized by someone else, you'll have documentation so that if a competitor is using your trade secret, you can go after them and convince them, if not sue them and stop them from using your trade secrets, right? And what's the cost of trade secrets? It's practically free. I mean, once you set up the system, I set up these systems all the time. You have a method for documenting, and it's usually something, if you have an IT department, you have outside software vendors. Once you set it up, it's just a matter of utilizing it, educating your employees to fill this system so that you have your trade secrets documented, date stamped, so that you have them well secured as a trade secret, limiting access to these important secrets to those who need to know about these secrets. Engineers who certainly know about your source code, marketing people who know about your valuable marketing and sales trade secrets, right? Customer names, customer lists, opportunities in markets out there where there is this market need that people are longing for the certain product with certain features, right? That might be known to some other people, but your company knowing this and having the ability to develop a product that meets that need, it can be a very valuable trade secret, right? And the risk of loss, there's risk of losing everything, but the risk of loss is manageable and it can be greatly minimized once you certainly understand, audit what are your trade secrets. You're auditing all these at the same time, your inventions, your patents, your trade secrets. You put them all into one place, then you sort them out when you're deciding what you want to protect, if anything. So the structuring your IP portfolio, once you begin to understand what is your competitive advantage with your trade secrets, your intellectual property, your patents, your copyrights, right? Follow the business goals. So you want to focus the protection on things that further your business, whether it's making your product exclusive, you're the exclusive provider to the world of these products, or to regions where you have protection, or there's areas of revenue. For example, the Hewlett Packard example, where you get a separate stream of revenue from a completely unrelated product based on your intellectual property. In that case, you would file those patents, a reasonable amount of patents in different geographies that protect that revenue stream that's reasonable so that you can profit from that revenue stream, right? And where do you look? The IP portfolio should mirror the management goals. So look at your competitors, follow their roadmaps. You can often understand, especially if they're a competitor of yours, they might be going to similar or the same, points of sales as you are. They're after the same customers. They might be after a big variety of customers, more or less than yours, right? You might be after going more customers. In order to plant risk in the roadmaps, you'll certainly be planting them in your own. You can use your own intellectual property. You infringe your own, of course, right? But with your competitors, customers, vendors, other companies, future competitors, you want to plant plenty of risk out there. In order to do that, you want to understand where the roadmaps are so you can plant risk by filing patents, copyrights, and protecting your trade secrets in the roadmaps of your competitors. Vendors, as we discussed in the example before, build your IP cache to negotiate. You want to have intellectual property before you even reach out to these vendors. If you've got a new idea, if you've got something that needs to be built, or if they have a product that you want to improve and you have some new inventions, you can end up getting exclusive use, even if it's for a short period of time, of these features that give you an advantage. The vendors can eventually possibly use it for other customers in the future. But if you have the intellectual property, you can control how they use it, when they use it, who they sell these new features to. It gives you the freedom to operate and choose other vendors. It also gives you the ability to use even your vendors' products for an exclusive amount of time. Joint development. Joint development is intellectual property is really key to joint development. When you're joining together with another company, overlapping skills and complementary skills, you're going to end up with intellectual property that is jointly made, that overlaps your intellectual property, that overlaps the partners in the joint development, their intellectual property. You need to figure out who owns it. And the best way to approach this at first in joint development is seize the advantage of superior IP. And what is that? You do it first. You're not going to have all the ideas. In fact, that's why you're doing a joint development. You're sharing expertise with another entity. But to the extent that you can come up with ideas that you expect to use in this joint development, protect. Copyrights, patents, and of course, brands too, right? You want to be able to take the advantage as soon as you can, maybe even before you sign the joint development agreement. Often there is the background intellectual property, and that's what you own before you even join this joint development. There is the intellectual property that is developed together with this partner, if that's what it is. And you've got the future IP in the continued research and development of the resulting product. Negotiating these contracts is really important to the advantage that you're going to end up with after this jointly developed product is made. So you want to make sure that you own as much as you can before you join it. When you join it and you jointly develop these things, you want to be careful to file patents on things that only you invented, not bringing inventors in from the other joint development partner any more than you need to. And when you do have inventors on both sides, now you've got jointly ownable intellectual property. They own part by their inventors, you own part by your inventors. And you want to make sure, as much as you can, you want to own all the intellectual property, even the jointly held stuff. and you could give them a license, or they could own it. They give you a license. The owner typically will pay for all the filing and maintenance and cost in protecting the intellectual property. So there's a lot of give and take there, lots of room for negotiation. When you're doing mergers and acquisitions, you're preserving value by combining IP assets with a business proposition, people, know-how, and trade secrets. So when you have this jointly developed intellectual property, you want to make sure that you have it, that it's transferable. If you do M&A, if you might sell off a product line or a division of your company, you might get your entire company acquired by a bigger company or merge with another company. You want to make sure that when you do that, that the IP is transferable so that you have value in this acquisition. Now, also in IP, or in mergers and acquisitions, you might, again, sell off a product line, sell off some intellectual property. Now, there's a way of preserving more value by combining IP assets and people, business propositions. When I say people, so a lot of companies will just shut down a division, sell off the patents, sell off the copyrights, sell off the hard assets, right? A better approach, when possible, is to look at this division. This division is composed of people. You have R&D people, marketing, sales, leadership. If you could bundle that together, not just the intellectual property, but everything that goes around the intellectual property, the know-how, the trade secrets, sell that off as a division, you might not see value in it. Your company might not be happy with the margins, or it might just be outside the direction of where your company wants to go, but it might be valuable to another company. You could sell it off for a much higher value, orders of magnitude more valuable, if you can preserve everything together rather than just a few IP assets, sell it all off together. And the only way to understand that is to understand the landscape of your IP, understand what IP you have, sell off this business division, and it can have much more value. The key is to understand the IP around it. Often what companies do is when they're cutting costs, they will audit certain things, or they won't audit. They would just sell off assets to make money, sell off assets because they're desperate to bring in some type of revenue. But you need to be careful. You want to make sure that you're not selling off the IP that you're leveraging or that's valuable to your ongoing business concern, right? This is where audits come in. You want to be very careful and audit things. So if you're cutting down the number of patents you're filing, if you're abandoning patents because you don't want to maintain them, you could sell them off and get licenses back. And you could maintain the patents that you are still using. Remember, too, that often you're getting, if you get involved in joint developments and other types of arrangements, you may be obligated to maintain your intellectual property, patents, copyrights, trade secrets, and trademarks, and know-how. So you want to be aware and understand what your IP is, so that if you start abandoning these assets or selling these assets, that you're not going to be in breach of contracts where the IP is underlying the agreement, right? Look at the fixed costs, see if you can optimize administrative costs, right? Legal services, foreign filing. There's so many ways to cut costs without completely abandoning your intellectual property, and certainly without abandoning the key intellectual property that your company depends on. So auditing, understanding your IP is really key. Here's a couple of examples of patent costs. I'm only putting this out there to give you an example of what investments that you make. You know, copyright costs, trade secret costs, those are really de minimis, very small compared to patent costs. So when you get the patent filed in the US, for example, you'll pay about $10,000. Getting a patent issued can be anywhere from an additional $10,000 to $35,000 over the several years that it takes to get the patent issued. There's maintenance fees, there's foreign filings. If you file in foreign countries, it goes up, and you got to pay for each jurisdiction. Each country has its own costs, right? And you have to pay annuities, maintenance fees beyond that, both in the US and in foreign countries. So be aware of how this cost expands. And at every level of these, you can work with your service providers or your internal people to keep these costs down item by item, rather than just abandoning intellectual property. You can greatly cut costs by auditing, understanding, and understanding the strategy around your IP and how it matches your business, so that you're not hasty or careless in just cutting costs. Yearly budget projections. So as time goes on, you develop patents last 20 years. You're developing these things, and you can file patents, several times a year over a number of years, and understand that when you do that, these fees, these costs, these out-of-pocket expenses they spread out, and you want to see how they increase. You want to see how they develop. So when you're auditing and you're deciding whether to cut loose these assets, stop maintaining these assets, to sell these assets, understand the cost structure over time of these things, and understanding what you're really cutting. In fact, at some point, like in 11 and a half years, once a patent, all the maintenance fees are paid, you don't need to pay anymore, and it's free. It doesn't cost anything to maintain that patent. You would not abandon that thing. You might sell it, but you don't want to abandon these things and lose the assets if they're not even costing you anything. Often it's a modest investment of maintenance or even filing patents to get an immense amount of value. You want to be aware of that. This is an example of ongoing cost over time, an example of 10 patent applications, and that's your yearly costs. And it can vary it can vary depending upon the technology, your regional cost of legal services, how well you've kept costs down internally and with your outside vendors, your outside service providers, your law firms, right? It can vary widely, especially when you get into foreign filing. So this is an example of how to keep an eye on costs, budget projections, so that when you're planning in the future, you can understand what those costs really are. It's not just a matter for your legal department. It's not just a matter for your CFO and your bookkeepers. You need to truly understand that and the strategy around IP, so you understand what the costs are, and if you want to cut them, how to cut them carefully. And lastly, it's really all about your people, right? Intellectual property is developed by people. It's not developed by artificial intelligence. In fact, you can't protect intellectual property that is developed by artificial intelligence. That's a subject for another talk. But for this talk, understand that it's people that create these things. I had a client that had, in fact, it was a very personal story where a woman developed this intellectual property, developed this very valuable audio video synchronization system, and it really improved the product immensely. And she was this young, quiet, she started as an intern, became an engineer, this employee that worked among, a big corporation where she wasn't really recognized. The CEO went through the trouble once a month at this all hands meeting to actually hand out the cash rewards for filing patents. You could pay, monetary awards or different things to reward employees for filing for patents and protecting intellectual property. And when I reached out to the CEO, I let him know that this is a very unique situation. This young, quiet, shy person actually developed something that was amazing. And when he approached her during the meeting, saved her for last, he would call the person up, called her up, and offered her the check, and would shake her hand with one hand and hand with the other. And in this case, held onto her hand and said, "Listen, I know how valuable this thing was. I know how hard you worked, how difficult it was. I want you to know this means a lot to me and to the company." It completely transformed this person's career. In fact, she ended up moving on to a bigger company and became an icon of research and development. There is nothing more powerful management tools for managing people than rewarding them with something that they did that no one has ever done before, and giving them kudos. It didn't take a lot of money. It didn't take a lot of effort. It didn't take a lot of time. but the value that was created in just recognizing this person for the thing that she did, it changed her career. And it also encouraged everybody around her in the company. Extremely valuable management tool to protect your intellectual property and also to give awards to individuals and teams. It certifies, it's the only thing, as I said before, that certifies that a person has created something that has never been done before. Nothing else does this. They can put it up on their wall. They can show it to their grandchildren, even after the thing expires. This is the thing that they invented. This is their fingerprint, their imprint on the world. They changed something, however big or small, but this is the thing that they created. Don't underestimate that. It can be extremely valuable. Thank you so much. Thanks for joining. You have all my contact information. Thanks for joining and joining me with this really valuable discussion about building intellectual property assets, protecting them. And thanks for joining me at Innovators Cafe. Thank you.
You've been tuning into Innovator Café, the entrepreneur go-to, with your host, attorney Dave Stevens. You can find more episodes on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and the website, stevenslawgroup.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.